I will briefly I will briefly introduce what we do before passing the virtual floor to Bertrand de la Chapelle. The Inter-Jurisdiction Policy Network, or INJPN for short, is a multi-stakeholder organization addressing the tensions between the cross-border internet and national jurisdictions. Its secretariat facilitates a global policy process engaging over 400 key entities from governments, internet companies, technical operators, civil society, academia, and international organizations. The mission is to inform the debates, connect stakeholders, and advance concrete solutions. INJPN works across 3 thematic areas in 3 policy programs: content and jurisdiction, dealing with cross-border content moderation challenges; data and jurisdiction, focusing on cross-border electronic evidence; and domains and jurisdiction, working on DNS regulation. The work of the Content and Jurisdiction Program focuses on topics relating to cross-border content moderation and jurisdiction issues, with particular focus on how we can manage globally available content in light of the diversity of local laws and norms applicable on the internet. The work of Content and Jurisdiction Contact Group is facilitated by the Secretariat using a unique methodology, enabling not only discussions in a multi-stakeholder environment, but also reaching consensus and producing various outcomes, which are publicly available on our website. The contact group comprises almost 50 key stakeholders and practitioners who meet virtually every 8 weeks. The Content and Jurisdiction Contact Group has produced a number of outcomes over the years, all of which can be accessed on our website, and my colleague will share the link in the chat. Notably, the toolkit Cross-Border Content Moderation was launched in 2021 and is also relevant to today's topic. It provides an overview of some of the key issues that arise when managing online content, considering diverse local laws and norms. The focus of the toolkit is on the process of cross-border content moderation, that is, identification of abuse, evaluation thresholds, choices of action, and recourse. A key topic under choice of action is the geographic scope of the action. Over the past 2 years, the Content and Jurisdiction Contact Group has discussed and worked on a number of issues, but one pervasive and continuing discussion question has been on the geographic scope of content restrictions. Earlier this year, in June, the framing brief on geographic scope of content restrictions was released, which documents these discussions and the tension points that emerged in these discussions within the contact group. I will shortly pass the microphone to Bertrand de la Chapelle to speak more on the outcome, but for now, a few practical comments. First, if anyone during the webinar has comments and wishes to take the floor, we would be happy to promote you to panelists, as Natalia indicated, in the last 15 minutes of a live discussion, for a live discussion. So in case you would like to take up this opportunity, please make a comment and include what you would like to discuss. Also, just to let you know that the Secretariat will remain available after the webinar to chat. So if you wish to remain, stay behind and carry on the discussion. I now pass the microphone to Bertrand.
Thank you very much, Julia, and welcome everyone to this discussion and this presentation. As Julia mentioned, the Internet and Jurisdiction Policy Network has, for more than 10 years, addressed the tension between the cross-border nature of the Internet and the patchwork of national legislations. And actually, there are a few topics that illustrate this tension more than the one that we're discussing today, which is the geographic scope of restrictions on content that is deemed illegal on the basis of national laws. I want to highlight at the moment, right away, that the discussions that we're having today is not dealing with restrictions that are made on the basis of the terms of service of companies, but exclusively on the basis of national laws. It is the result of intense discussions during more than 2 years within the Content and Jurisdiction Contact Group. And I must say that they were extremely intense and probably some of the most interesting that we had in the course of the last few years. This is a very difficult topic. And everyone agrees that basically extraterritorial restrictions that go beyond the territory of the particular country are, if any, under only extremely exceptional circumstances. But beyond this fundamental agreement, there are strong arguments that are developed in opposite directions. Some argue at the level of principle that the authority of a state is basically limited to the territory of that state, and that, furthermore, the mere discussion of criteria under which a extraterritorial extension of content restriction could be legitimate is actually running the risk of legitimizing the misuse of these provisions or this mechanism by a certain number of actors, and particularly for non-rights respecting countries. On the other hand, others defend also that when a country is fully democratic, as proper due process mechanisms at the national level, its decisions regarding the scope of content restriction should be respected. This is already a tension at the principles level. But on a pragmatic and practical level, we are seeing court decisions, and I will mention three: the Acoustic case in Canada, the CNIL decision of the European Court of Justice on the right to be forgotten, or the Glavischnik case in Austria and also in the European Court of Justice. These decisions do include an extraterritorial scope in their provisions, or address the question of extraterritorial scope. Moreover, the Digital Services Act that has been recently adopted by the European Union, in one of its articles, explicitly mentioned that there's a determination of geographic scope for any order, and that this geographic scope should not exceed, I quote, what is strictly necessary to achieve the objective of the order. So there is a legislation in Europe that is explicitly alluding to the question of the geographic scope. The framing brief that we published in July does not provide a prescriptive or normative position, but it is intended to reflect the intense discussion, as I said, that took place during more than 2 years within the Content and Jurisdiction Contact Group of INGPN. And it does this in two dimensions that I will detail very briefly. The first one is to document the context of this difficult issue. And the second one is to identify a few elements that we think can help further the discussion in the later stage. You will have in the chat, if it's not done already, it is there, the link to download the document itself. So briefly, on the first point regarding context, we address first this question of the risk of normalizing the practice. And in doing so, we highlight the importance of consistency of any order with international laws, principles, and standards of human rights, and also the question of the rule of law, the question and the criteria of necessity and proportionality, and also the necessary high degree of national due process that any country that is even considering such an extraterritorial restriction should meet. The second point was to highlight that there might be different situations to take into account when we're talking about public law and when we're talking about private law, and particularly regarding disputes between individuals. The third element is the potential excessive burden of recourse that may be put on individuals if they have to pursue in multiple jurisdictions numerous costly and lengthy procedures to obtain redress, for instance, in defamation cases. The fourth element is to address the question of the technical capacity or non-capacity of operators and platforms to implement nuanced content restrictions, either in a dedicated geographic range or in adopting measures that are more nuanced than just a full takedown or leave the content on. And finally, there is a risk of proliferation of conflict of laws and conflicting decisions between different jurisdictions if there is an extraterritorial extension of orders. That's for the context. The second point is basically to identify three elements that require further discussions and that are as follows. The first one is that there are questions regarding how important the criteria of the location of the poster of a particular content or the location of the intermediary itself is relevant. And that can mean that in general, one of the rules that emerge from the discussion is that those two elements, the location of the poster or the location of the intermediary, alone is not a sufficient criteria to justify extraterritorial extension. The second criteria, or the second element, is related to the scope of harm, in particular in regards to the geographical impact of the harm, as much as it can be measured, and the reach of the poster's account, the audience in particular that it can have, or its status as a public authority. And finally, third, probably the most important element is to introduce or to recall the notion that we already introduced in previous documents, particularly the operational approaches in 2019, and also in the toolkit that Julia had mentioned previously, which is the notion of international normative convergence, i.e., to what degree are laws that apply to different topics converge? Are the standards sufficiently comparable to justify international or extraterritorial extension of a content restriction? And in that regard, it is important to note that apart maybe from the question of child sexual abuse imagery, we do not have the transnational tools to have or to crystallize a sufficient multi-stakeholder consensus on what is the degree of international normative convergence regarding a particular type of illegal content. And that might be something that is worth exploring further. So this is the general structure of the document, and I didn't want to spend too much time explaining its details. I encourage you strongly to have a look at it and to look at the finely worded elements. But this, again, is a very difficult and controversial topic because it touches upon extremely sensitive issues regarding principles of international law, but also the question of sovereignty. I want to emphasize, before getting into our speakers, that this document is not a negotiated document that basically is validated by the organizations the different participants in the contact group are working in. It is a document that documents, again, the discussions that we had, and we hope that it will help inform the necessary discussions around this important topic, because we need to talk about the geographic scope of content restrictions. This is a problem, the implementation of which will become more and more visible in the future. So to discuss this in more detail, it's my pleasure now to open the floor or give the floor to two people who have been closely involved with this work. Let me present them successively, sorry. Wolfgang Schulz is the director of the Leibniz Institute of Media Research in Hamburg, and also the research director of the Humboldt Institute on Internet and Society. He has many other important roles in his more than 20-year career on communication and regulation, and we are very proud to have him as the coordinator of this contact group. Greg Kellis is a barrister at 5RB Chambers, specializing in media and communication law, and as he says, with a particular focus on conflict of law and jurisdictional challenges in relation to online torts. He worked in the British judicial system, in particular for the Lord Chief Justice for England and Wales, and interestingly enough, was for 7 years the editorial complaints commissioner at the Financial Times. And we are very happy to have him as a member of the contact group. So for both of you, for a quick 4-minute intro before we have a dialogue more informally, can you give a general sense of why it is important to discuss this topic, why it is so controversial, and how can this work help the debate? Wolfgang, maybe I'll start with you.
Yeah, thanks very much for inviting me. And I can't start my statement without thanking the content group members for the discussion we had the last month, because I really learned a lot. And it was really enriching and great to have this kind of debate, even though it was at times exhausting also, but sometimes necessary to learn something. I will just make 4 very brief points at the beginning to show why I personally believe that this is one of the fundamental points we have to talk about and we have to discuss. And the first one is obvious, but you have to state that again, I would say. If we have an extensive practice of states taking down content on grounds of the national laws on an international or extended scope, then we might end up with an internet that only contains content that is legal in all jurisdictions. That is something that has been discussed at the beginning of the internet, and it comes back again as a real issue. And I also hold the UNESCO chair on freedom of information and communication. And so a free flow of information and access to information is something we want to have as societies, is something which I feel very strongly about. So that is the first point why this issue is so fundamental. The second one is a personal remark as well, and that is, I think, my first contact with this problem, and that was a couple of years ago when in Germany we had the case where Angela Merkel, the former chancellor, was depicted together with a refugee, and some malicious groups posted that this refugee was in fact a terrorist. That was completely wrong. And German courts said that the rights of this refugee were infringed, and rightly so. And the question was, and still is, what is a proper scope of removal of this kind of content? My first approach would be to say it's just Germany, it's German law. But this refugee came from Syria. What about people in Syria knowing this person and now getting in contact with this information? So Syria as a geographical room might be something to consider, but the rest of the world, maybe it's different. Nobody knows them there. So the second point you have to be very nuanced when you think about the different interests involved here. The freedom of speech interests on the one hand, and the other, very often, this interest of a specific person and personal rights. The third aspect is, I believe we need guidance here. If you look at cases like the Glavishnik case, for example, that Bertrand already mentioned at his introduction, then you will see that they deal with a lot of European law questions. And then at the end, it's very briefly that they say European law says nothing about extraterritorial scope outside the EU. Here, the general international law principles apply. But what are they actually? What do they tell me in terms of that? That is not that clear. And the final point is, when you look at it seriously, as we did in this group, it becomes very soon very complex. You have to see that state actors are different. Are we talking about the legislator making the national rules about extraterritorial effects of state actions? Are we talking about a judge within the scope of the law deciding whether it's just in this country, it's beyond, it's the whole world where the decision is applicable, the content restriction? Or are we talking about authorities, public authorities, doing that. We have the distinction between different legal systems there. We have the special case of the EU, what is within the EU, which is a specific legal frame dealing specifically with this kind of extraterritorial effect. So third point, it is complex and we need guidance. And so that's why this discussion and framing papers like this are extremely important as far as I'm concerned.
Thank you very much, Wolfgang. Greg, and apologies, there are bells ringing in the background. I don't know if it produces something. Greg.
Thank you so much for having me along, and I'd like to echo what Wolfgang said about the quality of discussion. Sometimes very intense, sometimes very hard fought, but I also learned a great deal. And I'm grateful to all of my colleagues, particularly those I disagreed with, for their input. I think that there is some degree of international normative convergence that any takedown of any content off the internet engages the right to free expression. And whether that's articulated through Article 19 of the UN Declaration of Human Rights or Article 10 of the European Convention or equivalent provisions, everybody recognizes that that right is involved. And that has to be very limited, particularly where it's states applying their criminal or their regulatory, their public law. Slightly different provisions do obtain, however, where you're looking at private law. So this could be any of the personality rights. It could be torts of privacy or defamation or personal data protection, where the free expression right under, let's say, Article 19 of the UN Declaration has to be balanced against a privacy or personality rights right under Article 12 of the UN Declaration, the equivalent of Article 8 of the European Convention. And what courts are mostly doing is balancing these rights, but in balancing the rights under the tort of national law, however it might apply, they have to give regard to the proportionality of the interference in freedom of expression, even if the claimant wins. And we're seeing a large number of cases now, comparatively to where we were 10 years ago, where courts are having to grapple with this question and are finding that they don't have an awful lot of guidance. It's actually very difficult to say when they should be going beyond publication of their own borders. I should just put a pin. There's been a recent case in the English Court of Appeal called Minchione, pointing out that there's, as to the capacity, many publishers don't actually have the capability to fragment their publication on the internet. And even if they can do it at national state level, they often can't do it at the subnational state internal jurisdiction level. That was one of the issues in Minchione, where they said we can geo-block to the UK, but we can't do just England and Wales, but leave it up in Scotland and Northern Ireland. So there's a capacity issue where you actually sometimes see claimants who are very happy to limit the scope of their claim because they want to take advantage of, let's say, English law of defamation. And you have defendants saying, no, you need to look at the whole picture because this will affect the applicable law, or because we have some capacity issue. So it's very complex, and courts certainly need some degree of guidance, and litigants need to know where they stand in terms of what's actually at stake. We've talked about how heterogeneous this area of how different national systems balance the free expression and the personality rights. There are notable exceptions in Thailand's lèse-majesté, Holocaust denial laws in Germany. The United States First Amendment is an elephant in the room, but most major jurisdictions, certainly the European Union, India, other Commonwealth countries like Canada, have now fairly well developed case law on the balance of these rights. I think there is an important distinction between public and private law, and it's been one of the major things that I've cared about. There is a danger, however. There are really three threats to the traditional understandings of public and private law in this space. The first is fairly well rehearsed, although I think we see less of it than one might expect, which is essentially where you have foreign regimes, perhaps not rights respecting regimes, where individuals will essentially try to accomplish state censorship through, for instance, an official in that government bringing a personal defamation action. That sort of abusive process, I think most courts have a mechanism to deal with that, but it is an attempt to circumvent the difference between public and private law. The bigger threats, I think, are actually, firstly, the regulatory models for data protection, particularly EU's GDPR. European Union data protection, much like EU competition law, is essentially a public law regulatory scheme that has private law damages and other remedies sort of bolted onto the end of it. And that slightly obscures the distinction between public and private law, which is familiar around the world. It's somewhat sui generis. The third major threat, I think, is actually, and I'm not going to stray beyond the scope of this talk, but insofar as there are difficulties in states being able to do in public law on an extraterritorial basis, we will see them going to the platforms and essentially trying to do it by sort of the side door by affecting intermediaries. And similarly, if private law litigants feel that they can't get extraterritorial remedies through the courts, they will feel that actually they're better off trying to bring these cases to the platforms, who, albeit limited to one platform, will at least work on a global basis. And the danger of that is that we move disputes away from the transparent, open justice arena of the courts doing the balancing of rights, and we essentially privatize to a less transparent, private law system operated by the platforms. And I think that would actually be a tragedy for the proper balancing of human rights in this area.
Thank you very much, Greg. Just picking on what Wolfgang has said, it is clear that this is a problem that needs to be discussed more than it is today, for the reasons that a lot of courts and a lot of public authorities are going to be confronted with the problem. For your information, we don't have the time to discuss this in detail, but I strongly encourage you to look at the two decisions of the European Court of Justice that I have just mentioned regarding the CNIL case and the Glavishnik case, where there was clearly an inspiration from a notion of geographic scope of content restriction, even if it was not mentioned explicitly in reference to any kind of principles. But it was clearly adopting, in two different cases, slightly different implementation of the approaches that we're discussing here. The other thing, and I will come back to that, is the point that Greg was mentioning regarding the technical capacity of the operators that I'd mentioned, which is present in the document, to actually fine-tune, in any case, irrespective of the order, the geographic scope of the restrictions, and that varies considerably depending on the type of platform and depending also on their size in many cases and their technical capacity. But I want to maybe launch a more interactive discussions, and please, both of you, don't hesitate to chime in on what the other is saying. I would like to basically continue the discussion with you, Wolfgang. You mentioned the tensions and sometimes the intense discussions that took place, and how beneficial it is actually to understand the perspective of everyone. Can you tell briefly how the conversation has evolved during the 2 years in your view? What were the points of convergence? And particularly maybe elaborate a little bit more on the point you made regarding what are the international human rights that really apply and that can be leveraged in that regard, and how can we improve our understanding of international normative convergence?
Yeah, I'm happy to do that. In terms of the development of the conversation, I think it was really interesting to see that we started with. Do you really hear me still? Because
Yes,
I see.
we do.
Wonderful. Felt frozen a little bit, but just a feeling, obviously. We started with an approach which I really like with the Internet Jurisdiction Network, and that is, let's find a solution for a problem people can work with and have the human rights implication in mind as a guide there. We do not try to build normative documents, but we want to formulate guidelines that help people to make decisions that are human rights conform, and especially but not restricted to freedom of speech. And that was the starting point for this debate as well. But it emerged that, and Bertrand mentioned that already, that in this case, it's very hard to have a just operational technical debate on, let's assume there is a judge have to make this decision. What standards should he apply? What test should he apply or she apply? And because there is always the argument, if you give them the instruments, then they will use it. And my normative view is that they shouldn't use it, that they, as a standard, restricted to the scope. And this discussion came a little bit forth and back between these more operational level and this normative level, which was productive in a way, but showed at the end that it is hard to come up with something that is just a technical help for people who want to be doing decision making in this field. And that was the tension you asked about, was I think in between there, and some people felt very passionate about that, and I understand that, because I mentioned this issue. We don't want to end up with international information system in which we have as a standard that the countries with the most restrictive content regulation decides what is accessible on the internet. That's an extreme case, but it's possible under this regime. So I very much sympathize with that. On the other hand, if we see there are this kind of decisions being made, we need to make them in a freedom of speech friendly way. So my conclusion is twofold there. One is that this discussion has to be kind of funneled back to the normative debate. We have to have normative debates on what the actual criteria are. And we already talked about that. That is to make sure that people understand that the balancing between the different rights has to be done specifically for the geographical scope as well. So when I'm balancing the rights, I also have to balance in terms of what does it make to the freedom of speech restriction when I order content to be taken down, not just in this jurisdiction and others, and what does it bring additionally to the interests that I want to protect. And there might be cases where then we come to the clear decision, there is no gain on the one side, but there is more restriction on the other. And that means that it is not in line with international law. It violates freedom of speech. And I think we have to work on that. And then the more institutional question arises, when we want to come to standards there, is that something where multi-stakeholder agreements play a role in the normative framework, not just in their own field of responsibility, but as a reference point for normative aspects as well. So that, as a lawyer, interests me a lot, because I believe that we need this kind of institution building, and we have to couple these different fields of hard international law and this supposedly more flexible and, in inverted commas, weak realm of multi-stakeholder deliberations. And so it's an extremely interesting and extremely important thing. And that's again why I'm so glad that we could have this debate.
Thank you. I think the question of the dangers of normalizing the practice, if you try to define guidelines that are too precise and too detailed, was a core element in the discussion. And it was really interesting to finally succeed in putting in a document the balancing of those elements, or the reconciliation of those elements, by recognizing that there is a danger and that at the same time there is a need for elements of guidance to organize the discussion moving forward. Greg, any comment on this if you want? And if not, I have a direct question for you, which is, you were the one who brought, as you mentioned, the distinction between public law and private law, and the fact that one element in particular in the document that we produced, that the group produced, is alluding to the potential burden on individuals, and the situation where we're dealing with hate speech or terrorist content is significantly different from situations where you have defamatory cases, for instance. Can you elaborate a little bit on that?
Of course, I think, I mean, there was, I would say, very great unanimity for a strong application of the territoriality principle in anything in public law, criminal or regulatory. That's where the risk of one state infringing the sovereignty of another is at its absolute highest. And if there were to be any exceptions to that, they would have to be utterly exceptional. I do think the position is somewhat different in private law. So consider two types of claimant: a privacy claimant who is complaining about publication of image-based sexual abuse, sometimes called revenge porn, perhaps featuring a non-consensual act or an act that the woman in question didn't know was being filmed. She may have been underage. The remedy that person wants is for that no longer to be on the internet, no longer to be on the internet anywhere. To say, well, it's not going to be on the internet in, you know, your particular canton of Switzerland is not the remedy that the victim wants. She doesn't want it available anywhere in the world, and not least because of how easily geographic restrictions can be circumvented by VPNs and similar. That's a very different case in certain circumstances to, for instance, someone who wants to bring a defamation claim where there's much greater degree of difference between the laws of different countries as to when a defamation claimant should succeed. The laws are radically different. A person's reputation can be centered in one particular place, and they can get effective vindication from the courts of that place saying, this isn't true, and you know, we grant you however much money to in damages to assert that it's not true. That might well be enough. There's no need actually for the court in granting an injunction against republication to worry about publication elsewhere where the person isn't known. So private law is somewhat different in terms of the remedies often that people are seeking, but it's also different because states are not as concerned about, as it were, their own citizens submitting often voluntarily to foreign jurisdictions and having courts abroad determine cases that involve the rights of their citizens. So almost no member states, for instance, have a particular problem with their citizens signing up to contracts where the exclusive jurisdiction to determine breach of that contract is outside of the country. There is a backstop there, which is where a foreign court makes a decision. It might be possible for a state to resist enforcement on grounds of public policy. So, for instance, the United States says that even if you get a libel judgment from a foreign court that did have jurisdiction over the dispute, the Americans submitted happily to the foreign court for adjudication, it will not be enforced in an American court under the Speech Act. So the states have a backstop for enforcement, but they tend to be much, much more relaxed about courts assuming jurisdiction. And so where you have particular types of personality dispute cases, privacy, defamation, any of the torts or other causes of action that fall into this privacy right arena, some of those need to have a remedy that's global. Otherwise, there's almost no remedy at all. So child sexual abuse, revenge porn, I think are two particularly good examples. And there is that international coherence where almost all states appear to at least acknowledge that this should not be allowed, subject to their own versions of national law that apply. And so the question in private law is often not the binary one of should this foreign state be allowed to censor on our territory. Actually, the question of jurisdiction in a private law context is there is a dispute between a claimant and a defendant over global publication. The remedy has to encompass global publication. The question is one of allocation. Which court is the most appropriate to actually be able to deal with that, to stop courts that are not appropriate from weighing in? And that has to look at the sort of the twin lodestars of private law jurisdiction, which is predictability for a defendant who understands where they might be sued for their conduct, but also a certain degree of certainty, you know, for claimants to know they can sue, but also that there has to be a proximity between the harm suffered and the court that's hearing the dispute. You can't just pick a random court and say they're going to, you know, Iceland's going to deal with all cases where the claimant's name begins with A. There has to be a proximity between the court and the dispute for the purposes of the interest of justice. And that's not to in any way say that most of the time court should be acting on an extraterritorial basis just because the claim is made on the basis of privacy rights. Again, extraterritoriality will normally be the exception. It must not be the rule. But it's more possible that there will be those exceptions in private law, whereas the group was much, much, much more hostile to those exceptions in public law, I would say.
And I think you make an important, you use an important word, which is the notion of recourse and the distinction between, or remedy. And the distinction between public law and private law is that when in private law, there is something that is directly harming a person, and you mentioned the question of revenge porn or blatant cases of defamation, then the question of the burden and the remedy for that sort of thing is bringing a perspective that is slightly different from whether something that is illegal, for instance, in Europe regarding Holocaust denial, closely linked to freedom of expression, doesn't have the same international normative convergence.
Yeah, states don't have human rights in that sense, and states, in trying to apply their criminal law, are almost trying to preempt several steps in advance possible harm to their populations. But a private law person bringing a claim has suffered actual harm as a person with human rights, and I think that puts the claiming parties in different positions.
Wolfgang, any comment on this question of the articulation between private law and public law, particularly in connection with what I was mentioning earlier, like the international norms and how much can we use international human rights standards and treaties to feed into the international normative convergence?
Yeah, so my feeling is that it's a little bit maybe easier in this realm of private law because it has already the focus on concrete harm. And so to see where actually this harm happens, and Greg is completely right in pointing out, see the position of this person when you have this revenge porn case or whatever it is, then you can really have a tangible interest in taking down content elsewhere, because you can demonstrate that there is harm when it is there. That is not often the case when we have public interests, when we have interests of states and they demand content takedown. And I think we need them to demonstrate why that is necessary if you want to consider that this kind of extraterritorial effect is possible in this case. So first of all, I completely agree with Greg that this distinction between the different types of cases is existential for this debate to be rational. And maybe the two fields can learn from each other, because this test of harm and their geographical dependencies is, I would say, more established and more nuanced and more already enshrined in concepts and tests in the private law than it is in a more regulatory environment, where you very often have the tendencies of state to say, as broad as possible, I want to extend my influence, my values that are enshrined in this regulation. So we definitely have to see the distinction between these different realms, but also maybe can learn from each other in terms of tests and precision of allocating harm.
Thank you. I noticed that we have actually a question in the chat, which is basically, I can read it because it's an interesting way to formulate it. From Laurie Schulman. Perhaps there needs to be an international agreement or private system that allows for the clear-cut cases that cross borders and allows for appeals to local courts. And the comparison is with, of course, the environment of the UDRP in the domain name system at ICANN. And the question was that considered? Can that be envisaged? What kind of international agreement could be explored, and that connects actually to a question I wanted to throw in that regard, which is what are the respective roles of the judiciary and the legislators? So how much can we formalize the this question? I mentioned that the Digital Services Act is making an allusion, which is a very simple sentence without dealing that much with the implementation. So what is the relation between what can be formalized either at national levels or regional levels or international agreements, and what is going to be the responsibility of the courts to make the determination? And maybe is there a distinction here between the the common law and what is it? There's common law and the other one.
Civil law.
Yeah, civil law systems and common law. Thank you. Sorry for my. So the question from Laurie is, can there be international agreements around this? And if not, how does that function with the distribution of responsibilities between courts and legislators? How much can we structure the criteria and the decisions? Great.
If I may, I mean, the European Union has done an enormous amount of work in this area generally. So the Brussels regulation, which applies to all EU member states, and then the equivalent Lugano Convention that covers the other European states in EFTA. The Brussels Lugano system really does two separate things. There's a question of allocating jurisdiction in private law, civil and commercial disputes, and then secondarily, the enforcement and recognition of such judgments. I'm going to leave enforcement and recognition to the side for one moment. The Brussels system works for all civil and commercial disputes, contracts, torts, employment, insurance, lots of things. It has had to deal with this sort of case, and there's a trio of cases in particular from the Court of Justice on Brussels Lugano in relation to internet publication, Cheval, eDate, and most recently BOLAG Supply-Singen, setting quite mechanistic rules for which courts can do local only, which courts can do global, which courts have jurisdiction, and that can be done through international agreement. The notes of caution that I would sound is that the Brussels Lugano system, particularly in this area, is highly mechanistic. And that can be slightly difficult. The common law has a much more general discretion in courts for forum conveniens to sort of pick the best court that's most appropriate to deal with disputes. Brussels Lugano, because it's so complicated with so many countries, is quite mechanistic about the allocation of jurisdiction. And I suspect any attempt at international agreement would have a similar issue, and that can be quite difficult. Similarly, when the EU tried to harmonize conflicts of law rules in the Rome regulations, Rome 2 specifically carved out this area of law. It's so difficult because there is such heterogeneous differences between the balancing of rights in different media law, even just within the European Union. So international agreement is possible. We know that from Brussels Lugano, but there are downsides to doing it, and it can be very difficult to achieve, even if Hague was there. The thing that actually might facilitate this an awful lot better, there's a real risk of chilling effect, where courts are only prohibiting publication on the internet in a local sense, but defendants or intermediaries are throwing up their hands and saying it's just too difficult to do, we might as well take it down globally. The thing that would actually almost grease the wheels to a better functioning system in this way is perhaps an internet protocol, but some degree of international agreement and the facilitation of tools to make it far, far easier for people to essentially geo-block, even if you're talking about individual bloggers, to be able to geo-block by jurisdiction, so that actually becomes part of the normal process of publication. Now, that will obviously set off concerns about fragmentation of the internet, but in terms of avoiding the chilling effect of defendants blocking more than they are legally required because they lack technical capacity or they just can't be bothered to do so, I think that's probably an area for international agreement that might come a lot quicker than a Hague Convention modeled on the Brussels system.
Thank you. I think, and I come to you, Wolfgang, but the point that you raise is connected to what I was mentioning at the beginning, which is we are not addressing here takedowns or content restrictions on the basis of terms of service, which is actually the natural default if there is no capacity to have an appropriate recourse. And here the takedown might be more global actually than the geographic scope that we're discussing. But I want to come back and I give you the floor, Wolfgang, maybe by reiterating something that was interesting in Laurie Schulman's comment, which was clear-cut cases that cross borders. And she mentioned the UDRP because there is a significant set of pre-criteria that create a threshold for obviously clear-cut, unfair or bad faith practice, etc. And I want to come back to what you were saying, Wolfgang. You mentioned the question of revenge porn. There are no legislation, whatever we call it, I mean, non-consensual sex images sharing. There are no legislation in every single country that basically covers this explicitly. And in most cases, it is covered through the angle of privacy protection, or private life. However, when we had the discussions, in as much as there was a strong consensus on child sexual abuse imagery, and there was a discussion saying, basically, apart from that, there's not sufficient international normative convergence. Could it be envisaged to explore that on a topic-by-topic basis, in a topic like non-consensual sexual images sharing, where I think there is an international normative convergence and multi-stakeholder agreement that this is strongly illegal, inappropriate, damaging, gender bias, etc., that there could be a special procedure for that sort of thing that would provide guidance. Is an approach by sector something that would help document the convergence, or shouldn't we explore this because it would be too complex?
I'm not so sure, but maybe just one remark to the comparison with the EU, which is tempting a little bit, but I think on the other hand, problematic as well, because the whole EU is about accepting extra jurisdictional decisions, saying that in one country it has been controlled, and so we accept it in other countries. And even within the EU, that's complicated because in some cases we know that there have to be backstop powers of the national state and member states and so on. And to think about an international order where you have that is bringing back the dreams of a world information order, and it's from years ago. And I'm not really convinced that that is something that on the content level will happen. About this topic by topic approach is definitely something we could try. And when I remember our debates in the group, we did that. We were talking about specific topics. I'm not convinced that it's really realistic to come up with categories there that are well defined enough to really help the lawmaker or the judge to work here. But the discussion about them can be informative in the way that it gives us a more nuanced catalog of criteria that are already in this framing document, but can be nuanced to say what procedurally has to be taken into account when a judge under a specific jurisdiction is considering is that appropriate and proportionate to have an extraterritorial effect in this case or not. So my answer would be it is good to discuss around those cases, makes it concrete, but that we end up with a system saying that we have these 5 categories, and then we can say with this it's more okay to consider these global effects and others we have not enough convergence. That is something I'm not sure that we can achieve that. But I would say it's a good instrument to get to a more nuanced catalog of criteria.
Greg, any comment on that question? We have, and please don't hesitate to put topics or questions in the chat if you want us to, or the Q&A to go through.
I know there's always been a nervousness about anything that almost looks like the content group sort of weighing into normative evaluations of what substantive law should be, particularly substantive national law, because we're all bringing such radically different perspectives. I think there probably is that international. I mean, the work that's been done, the comparative law work that's been done by the content group, I found really useful for understanding. Yeah, there are some areas that there is just no international agreement at all. Defamation, I think, is one. Lèse-majesté, Holocaust denial laws. I think there is an agreement on child sexual abuse material, and rightly so. But even what one might have imagined,
international treaties in that regard. Sorry, and international convention.
Exactly, and it's capable of that agreement being reached. Even image-based sexual abuse, so-called revenge pornography. There have been sort of at least 2 cases of which I'm aware, and one in the Vermont Supreme Court that upheld a law prohibiting revenge pornography. One, I think the Texas Court of Appeals felt that the law was too broad and an infringement of the First Amendment because it didn't have regard to the subjective intent of the publisher. Now, in Europe, the subjective intent of the publisher really would not particularly, at least in a private law action, for privacy damages. So it's the sort of area that one might expect international convergence. It's surprising how little international convergence there actually is, and I think we've done a great job of documenting the heterogeneity. But I think trying to sector off things that we might expect agreement, I suspect won't get us very far.
Thank you very much. We have 3 minutes until the formal end of the session itself, and so I will wrap up this part. And as we said, we will stay for a few minutes more if you want to continue the discussion. There's one thing that I really took on a personal basis from the whole discussions that we had during those 2 years, which is that the complexity of this issue is vastly underestimated, and that there is something that is going to be, as Wolfgang said earlier, going to be handled on a piecemeal manner from a lot of different actors. There will be elements in different legislations. There will be maybe elements on topical legislations, as we explored at the end, because there might be different countries that will adopt specific vertical regulations regarding certain types of content. This question of the international normative convergence, one of the key messages that we got from the group is that we do not have the spaces nor the processes to document international normative convergence and to be able to have a clear vision of what are the different legislations in different countries regarding a particular type of situations, and that it is clearly something that needs to be discussed in a sufficiently multi-stakeholder manner. I want just to put at the end of this call one element, which is that recently I understand that there is a discussion that is going up to the Supreme Court in the US regarding the divergences in jurisprudence between different states regarding precisely the authority to regulate the moderation practices of companies, because some states are considering that, I mean, Republican states apparently consider that the platforms are canceling or repressing expressions of conservative views, and on a more democratic state, there is a pressure to have more elements addressing hate speech or harassment and things like that. And the US Supreme Court will have to address this thing, which brings an interesting twist to the discussion that we've had, which is that we may have this problem of geographic scope, not only between countries, but also within federal countries with disparate legislations at the level of states. And to argue in that regard, given the recent decision by the US Supreme Court in the case of overturning Roe v. Wade, there are going to be very strong legislations regarding abortion in different states in the US, where the content that will be posted regarding promotion of certain activities and abortion clinics, etc., might fall under the purview of the discussions that we've had today. So I don't think the discussion is over, far from it, and we hope that this document is helping framing for the different actors involved the exercise of their authority, and also the discussion that needs to continue to take place. So we can close and finish the recording at